Hello everyone, we will now continue our discussion on crimes against property, particularly Article 299, robbery in an inhabited house or public building or edifice devoted to worship. Article 302, robbery in an uninhabited place or in a private building. Article 303, robbery of cereals, fruits, or firewood in an uninhabited place or private building. In these particular articles, we'll review the term uninhabited place, which was first mentioned in Article 14, Paragraph 6 of Book 1 of Revised Penal Code, particularly and as one of the aggravating circumstances, where it was mentioned that the crime be committed in the nighttime or in an uninhabited place or by a band. So what does an inhabited place or despoblado mean? It means that for a place to be uninhabited, it is determined by whether or not in the place where crime was committed, there was a reasonable possibility for the victim to seek or receive some help. So if there was no way that the victim can receive help even if the next house is near, it is still uninhabited. So uninhabited place presupposes that the place is at a considerable distance from the town or the nearest house or could not readily be seen. Another is if the victim was killed in a banca not so far away from another banca at the sea, the place is uninhabited as it was difficult for the victim to receive some help. So in a place where there are no houses at a place at a considerable distance from town, or where houses are scattered at a great distance from each other, it is still considered uninhabited. So when the victims are the occupants of the only house in the place, the crime is committed in an inhabited place. Having discussed the term uninhabited place, let us now also review the meaning of inhabited place. So, inhabited place means any shelter, ship, or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom. A place is also considered inhabited where the place of commission of the crime can be seen and the voice of the victim can be heard from a nearby house. So if we have inhabited, we'll also discuss the meaning of dependencies of an inhabited house or yung nakakabit sa inhabited house. So what are dependencies of an inhabited house? These are the interior courts, corrals, water houses, granaries, barns, coach houses, stables or other departments or enclosed places contiguous to the building or edifice having an interior entrance connected therewith, and which form part of the whole, shall be deemed dependencies of an inhabited house, public building, or building dedicated to religious worship. So with this discussion on Article 299, 302, 303, let us listen to report of Johayr Salman.
Hi everyone, I am Salman Johayr, criminal law school student under attorney Dimpna. Now I am here to report on Article 303 of the Revised Penal Code. Article 303, robbery of cereals, fruits, or firewood in an uninhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. In the case of People versus Lucio Rada et al., GR L 16988, dated December 30, 1961, the accused were charged with the crime of robbery in an uninhabited house under Article 302 of the Revised Penal Code for stealing 9 sacks of palay in a bodega owned by Isidro S. Bastida. However, the accused did not plead guilty during the arraignment, and now the counsel for the accused filed a motion to quash on the grounds that the offense alleged in the body of the information did not fall under Article 302 of the same code, but within the purview of Article 303 of the revised Penal Code. The issue of this case is whether or not the accused were properly charged in court. The Supreme Court held that no, the offense committed by the accused does not fall under Article 302 of the revised Penal Code, but properly comes under Article 303 of the same code. In People v. Messiah 65 Field 267, which involves similar question, the Supreme Court stated that cereals are seedling or unhulled, which are immediate product of the soil. Hence, the taking of sacks of hulled rice does not fall under this article, but under the paragraph of Article 302 of the revised Penal Code. Now in the case at bar, based from the foregoing, it would seem clear that palay, or the local name for the unhulled rice, is cereal and is included in the term similia alimenticia used in Spanish text of the revised Penal Code, as it is grain in its original state, and under proper condition, it can germinate into the plant that produces it. Therefore, the order appealed from is hereby affirmed, charging the accused of the crime of robbery of cereals, fruits, or firewood in an uninhabited place or private building under Article 303 of the revised Penal Code.